Can we ambush the opponent, the defense, in a medical malpractice case and not tell them which medical experts we are bringing in to testify on our behalf? You want to know the answer? Come join me for a walk near downtown Manhattan, near where you can see the Statue of Liberty, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no, we cannot ambush the defense. We can't simply show up at trial and now, on the day that our witness is expected to testify, simply spring it on the defense attorney and say, ha, we didn't tell you. We didn't tell you who we were bringing in, and we didn't tell you what our expert was going to say. So good luck trying to go ahead and cross-examine that witness. No, that's not going to work. In fact, if we tried that, you know what would happen? The defense attorney would jump up out of his seat, yell out objection, and then complain to the judge that we failed to notify him that, number one, we were bringing in a qualified medical expert, number two, that we failed to notify him about what our expert was going to say, and number three, he'd also say, although he's not permitted, that we didn't notify him who we were bringing in. Now, are all those valid? Actually, they are. Almost all of those. So now, you may not know this, but in many years past, what would happen was the attorneys who would try these cases, now they would not disclose the names of experts, and they would not even disclose the fact that they had a medical expert to their opponent. So what would happen? They would get to trial, and now the judge would say, okay, Oginski, call your next witness. And now we would say, okay, Your Honor, at this time the plaintiff calls Dr. Jones to the stand. And now the defense attorney would get all upset, saying, we didn't know that Oginski was bringing in Dr. Jones to testify. We don't know who Dr. Jones is. We don't know what his qualifications are. And importantly, we have no idea what he's going to be talking about on the witness stand. So now we, the defense, are at a significant disadvantage. Well, guess what? The defense would play the same exact game. When it was time for the defense to bring in their medical experts, they would fail to disclose who they were bringing in and do it at the very last minute. So now we, as plaintiff's attorneys, would be in the same exact position they'd be in when we would pull that stunt. The courts finally got fed up with that nonsense, and they said, you know what? There will be no more trial by ambush. No more. From now on, as you get closer to trial, each side is now required to notify the other side that you are bringing in a particular witness. You are required to tell the other side exactly what this witness is going to be testifying about, and in some cases, we have to disclose the name of that witness. Now you might be saying, wait a second, I heard in a personal injury case, in an accident case, that expert witnesses their names have to be disclosed. And that is true in New York. However, in a medical malpractice case, that is not true. We do not disclose the names of our experts. And why is that? If we go ahead and disclose the name of our medical expert, there is the possibility that the defense, through their various organizations and medical organizations and professional organizations, may exert some undue influence on our expert and convince him or her not to testify. So that is one of the key reasons why we don't disclose the names of our experts. But here's something else you may not be aware of. Although we don't disclose the names of our experts, we are still required to disclose the credentials, meaning all the training that this witness has. And ironically, once we do that, the opposing attorney can then take the credentials, plug it into a computer program, and it will clearly identify who our expert is. And you should know something else. The same exact thing happens on the opposite side. When the defense notifies us as plaintiffs, as the attorneys representing the injured victim, they do the same exact kind of game. They notify us that they've hired a medical expert. They tell us They tell us that they've hired a medical expert in a particular specialty. They provide us with his or her credentials, and we do the same exact thing and plug in that information into a computer program, and now we identify exactly who that expert is. Now, why is that important? It's important because now each side is going to do their own investigation to try and dig up information about this particular expert. They're obviously going to do a background search, they'll do a Google search, and then they'll try and find transcripts of prior testimony that this witness may have given in other cases. And that can be very useful and very fruitful at the time of trial, especially if this witness has testified about something that contradicts some of the issues in this particular case. So that can be very useful at trial if we find some good information about this particular expert. So getting back to the question I raised at the very beginning, and by the way, you should be able to see the Statue of Liberty in the distance back there. I don't have the zoom on right now, but you can see it. It's right over there. So getting back to the title of this video, can we ambush the defense and gain a significant trial, tactical advantage at trial? The answer is no, we can't. We have to notify the defense who we're bringing in. We have to provide them with their qualifications. We have to provide them with a detailed recitation of what our expert is going to be talking about. And likewise, the defense has to do the same. Trial by ambush, no more. So why do I share this great information with you? I share this information with you just to give you an insight and an understanding into what goes on in these medical malpractice cases in the state of New York. And plus, I wanted to give you a view from the tip of Manhattan, across the water. That's New Jersey over there. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter happened when the helicopter was not passing by, creating all that noise, no, if your matter happened here in New York, and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.